Good morning, Mr. Bedderson.
Good morning, Chief Justice. Good morning, Commissioners.
Are you well, sir?
I'm very well, thanks.
Thank you. You hold a BA LLB degrees, am I right? From the University of Durban, Westville.
That's correct, Chief Justice.
And in fact, you were an attorney for about 2 years, am I right?
That is correct, Chief Justice.
And have been an advocate for about 21 years.
It'll be 21 years in July.
Yes. Just by the way, any reason why you haven't become SALT yet?
It's quite a good question, Chief Justice. It's a decision that I considered at the Durban bar. There's, in my view, an over-proliferation of silk. In fact, we probably reaching a stage where we're going to have probably more silks than juniors in time to come. There's a shortage of senior juniors, and as you have seen from my application, I've got quite a busy trial practice, fortunately, and it's always a difficult decision to give that up, and making the decision to take silk. I think the benefits really is that you keep your fees affordable, and you make yourself readily available to the attorneys out there who get good value for money from a senior junior. So that's one of the considerations.
Yes. And for how long in all would you say you've acted?
I beg your pardon, Chief Justice?
As a judge?
I started in 2019 in my first acting stint. September 2019 through to October 2020, a total of almost 24 weeks. I was due to act on the 18th of January 2021 to February 2021, when I was informed that the minister had taken the decision that I've acted too much in the past. So at the time, it was a bit disappointing, but nonetheless, I'm here.
Yes. And you're ready, otherwise you wouldn't be here, am I right?
I'm ready, Chief Justice, yes.
Yes, thank you. Colleagues, let me have the names of those who have questions for Advocate Bedderson.
Madonsela. Nyambi. Wazimshengo.
Matolo Jepu.
Barnard.
Schlemmer. Tepe.
Baba.
JP.
Thank you, Chief Justice. Mr. Bedderson, you started your career in 1995 as an articled clerk.
That's correct, Chief Justice, Judge President.
And you've been in and out of the High Court, KwaZulu-Natal, since then, ever since then, as far as I can recall.
I've been fortunate enough to have a litigation practice right from the very beginning. The principal that I got articled with was now deceased, Vassett Supal, had a one-man practice, and we essentially represented the man in the street. No corporate work was available to us at that stage, or parastatal work. So one had to dive in straight away. You had to either sink or swim, I suppose.
And you've been an advocate now for 21 years.
That's correct.
And your practice, what does that largely consist of?
It's a varied practice. It involves commercial work, banking work, insolvency work, road accident fund work, medical negligence work. I've had experience in dealing with some shipping matters from time to time, not a lot, and labor stuff as well. So it's really a broad-based practice, if I may use that term.
It's about the shipping work that I want to ask you about.
Yes.
well, I've been in the KwaZulu-Natal courts as a practitioner and as a judge for more than 40 years. And shipping work has largely been reserved for white practitioners. It's also in the last couple of years now that I've seen Black practitioners coming to court with shipping matters. There are not many practitioners that practice in maritime law, as far as I know.
That's correct. That's correct. And initially, when I first came to the bar, a gentleman by the name of Derek Reed, who's now immigrated to Switzerland, and I think he worked for Denise Rates as it was then now, gave me my first shipping matter. And of course, with senior colleagues at the bar who have an open door policy, one approaches and debates things and gets the show on the road, so to speak. But that didn't last long. I'm not sure whether the work dried up or not, but I then moved on to other matters. And then in this year, January this year, during the recess period, I got a telephone call from a firm in Cape Town, a well-known shipping firm in Cape Town, inquiring whether I could assist by bringing an urgent application in a shipping matter, which I did. Wanted to research the law again because I hadn't done it for some time. Spent the weekend doing that and preparing the papers, and of course moved the application successfully on the 4th of January, which was a Monday. So yes, the shipping work is not readily available to Black practitioners, but I also think you have to balance that against the fact that shipping work is largely dried up, I think, in the country. Now, just to go on, sorry, I know for a fact that there's a lot of new Black advocates that have attended the MLA course. So it seems to be a lot of stride being made by the powers that be to empower Black practitioners. But this is what I hear.
I want to move on to the RAF. The RAF have, well, taken on a new method of litigating these days, where they simply seems to just have abandoned defending claims, and which has resulted in the court roll, particularly in Durban, and to some extent in Pietermaritzburg, being clogged with undefended RAF matters. And I know that you do quite a few personal injury matters. Can you suggest any solution to the experience that we are now having in the High Court as a result of the way the RAF seems to be litigating these days?
Well, the RAF has an obligation to litigate responsibly, like any government or parastatal entity. Their failure to appoint attorneys, and for whatever reason, has a detrimental effect on the delivery of justice as a whole. You've got legitimate claimants, provided their claims are legitimate, not fraudulent, that expect their matters to be finalized without undue delay. And I think it's unacceptable that that approach has been adopted. I'll give you an example of how I dealt with a RAF matter in the recent past while I was acting. Counsel came through to see me, informed me that the fund is not going to send anyone down to court, not going to appear, and inquired from me whether his attorney was present and whether she was prepared to give evidence to disclose to the court what steps she's made to alert the Road Accident Fund that the matter was in court and what exchanges they've had. She went into the witness box, gave evidence to the effect that there was correspondence between herself and the claims handler. The RAF was aware that the matter was in court. And of course, on that basis, I allowed the matter to proceed. It was a loss of support claim. And then the plaintiff gave evidence. And that's how I dealt with it on a constructive, proactive basis. I think it's untenable that they can hold the courts to ransom in the manner in which they have. And I understand they've got problems. I think there's financial problems, but that's a different issue, I suppose.
Other matters I'd like to ask you about is medical malpractice. Of course, we have these huge claims for loss of earnings, future medicals, which is causing enormous problems for the Provincial Department of Health. And we've had this recent decision, I think by the Constitutional Court, that payment of future loss of earnings and medicals could be what they now refer to as, I think, the golden ticket. What's your view on this?
I think in principle, there's nothing wrong with it. I think the problem is the evidentiary burden that the MEC for Health will have to overcome. It's all well and good to say that I can provide services just as good as the private sector. But one knows what the problems one has in provincial hospitals, in the public health sector. We come from that background where it's overburdened, it's understaffed, and now we're going to have a situation where an undertaking is going to be given to provide therapy to these CP children, as well as people that are not litigating. So in principle, yes, I think it can work. And it might work in certain centers. For example, in Cape Town, where they've got the Children's Hospital, it might work well there. And of course, that'll lessen the burden on state coffers, because it is quite a huge burden that they face with all these claims. So yes, it can work, but I think it has to be case specific, and they're going to have to lead evidence. It's all well and good that the Constitutional Court says that it's quite appropriate to provide those services in lieu of pain and damages, so to speak.
Most of the other candidates that have applied for positions on the KwaZulu-Natal bench, I think some of them are known to you.
Yes.
My question is, what do you think you would bring to the bench?
Well, JP, you've mentioned that I've been practicing now for approximately 24 years, litigating for 24 years. And I think it's quite easy for someone to tell this commission how forensically capable they are. But I think more importantly, what I do bring is the right temperament. I get on well with all my colleagues. I treat people with respect and dignity. I'm courteous to people. And I think that's what we need in the modern era. We all come from an era where people were treated quite badly in the past. Practitioners, litigants, you were frightened to appear in court as a young practitioner. You were humiliated from time to time or shouted at. But of course, litigation is not for, if you can't take the heat, don't come into the kitchen, I suppose. But we've got a different approach now. You know, we're not there to frighten juniors. We're there to assist, help. One example I'll give you in motion court, I had a young man, I think he was an attorney, who was bringing a Rule 57 application for appointment of a curator. When I read the papers in preparing for motion court, it became quite evident he hadn't read the rule. There's another application of a similar nature further down the line. I think it was a matter 22. And when his matter was called, I think it was number 3, I said to him, I said, Mr. So-and-so, you hadn't read Rule 57. I said to him, just hold on. I said, who's your matter 22? And a young lady stood up. And I said, she's done it right. I said, I'm going to adjourn your matter, senior DA. I'm going to grant you leave to supplement your papers, but talk to her and she will be able to help you going forward. Now, ordinarily, one would be irritated that you've got a young practitioner coming to court, not reading the rules. And of course, you shout, you remonstrate with him. But I think that's not the way to go. I think you need to be sensitive to people coming to the High Court, especially for the first time. And instead of breaking that spirit, encourage it. Now
Talk about diligence. I don't think you have any parterres or any outstanding judgments. Am I correct?
I don't know.
What is your, if I may put it this way, your turnaround time in getting a judgment out? Because I know that you've written quite a few. What do you have to say?
Initially, when I first acted, which was quite a daunting experience, I took 3 months to deliver the first judgment. And thereafter, I think judgments were delivered within 2 weeks, within a month. I think the problem is you sleep with it. If you don't get it out, it robs you of your sleep. And I like my sleep, Chief Judge.
You've acted both in Durban and in Maritzburg, as far as I know.
I have, yes.
Yeah. Just off the top of your head, what do you think are the challenges in the KwaZulu-Natal High Court?
I think the big challenge we face is case management. For some reason, in Durban, it seems not to be working. I don't know what the problems are, but we need to sit down as a collective and work out what's going wrong. And maybe people like myself who has the litigation experience on both sides of the spectrum, acting for indigent people and having the benefit of acting for commercial entities and the like, is to use that experience to enhance service delivery. Pietermaritzburg doesn't seem to have that problem. Somehow things are running a little more smoother in Pietermaritzburg. But then, of course, the workloads are different. Durban is a busy center, so one can expect you're going to have problems in Durban.
Thank you, Chief Justice.
Thank you, Judge. President, MEC.
Thanks, Jay, and greetings to Advocate Bedderson.
Morning.
Just one question. Now, almost 27 years into democracy.
Yes.
There's still a running debate around the transformation of the judiciary. Now, in your understanding, what should constitute these values that should underpin a transformed judiciary? Because at some stage we must agree, all of us, that we have really transformed from the past, which we all know, so that it accords with the values of the present. Thanks.
I think if I was part of this commission, what I would look for is to ascertain or identify people who have got a transformed mindset. You have to treat people with respect, dignity, be courteous, not be condescending. So those are the virtues we're looking for. And that's important to make the courts accessible to the general public and not frighten people away. So patience, courteous, you have to be fair to people and treat them as you'd want someone to treat yourself, I suppose.
What's your view on the argument again that says courts are still almost exclusively available for those who are moneyed, and those who don't have money can't access courts?
Yes. Look, there are practitioners where money is not of paramount importance. The person I mentioned who I started my legal career with was one of those people. We represented the man in the street. We represented people from our communities. We represented people whose houses were being taken away by the banks. Legal aid stuff, etc., things like that. Maybe the answer is to enforce pro bono work, oblige every practitioner to do at least one pro bono matter per term or things like that, but we have to be proactive about it. But having said that, people at the bar have come to the party, I think, maybe not in great numbers, but if there's a deserving matter, certainly my group, for example, we take on the matter and we'll forego fees. I've done it, other people have done it in the past as well.
Thanks, CJ.
Thank you, MEC. Advocate Madonsela SC.
Thank you, Chief Justice. Good afternoon, Advocate Bedderson.
Good afternoon, Commissioner.
First, a disclaimer, you and I started together
Yes,
when we were running main trials in the Magistrates Court, and we were members of the AFT together and throughout the years as well.
yes, I just remembered that you and I were appointed to be chairpersons of the Tax Appeal Board in 2008.
Yes,
Yeah.
I did more writing than you did. Now, my question is this. When I look at your questionnaire, item 4.2, seems to me, as I always quip with you, you are a father of many children.
Yes.
I asked this question. We have seen in the past that some judges find it quite difficult to stay the course simply because they just have so much burden with their children, and then half the way through, they say, no, we want to come back to the bar and practice.
Yes.
What's your sense about that? Do you have any comment?
It's on the subject of many jokes at the bar, I suppose having 5 children, but 2 of them are now adults. The one is well on his way. He is working and soon to be married. The second fellow is in his final year at university. But it's not all about money. If I said to my father, who's late now, that I couldn't afford to live on a judge's salary, he probably would have said to me, you forgot where you come from. So we'll survive on a judge's salary, Mr. Madansela. I don't have huge expenses except for the children, and we'll live within our means.
Thank you, Chief Justice.
Thank you, sir. Honorable Nyambi?
Thank you, CJ. Afternoon, Advocate Bedderson.
Good afternoon, Commissioner.
If you can share with us your understanding of the connection between democracy and the rule of law.
Well, the rule of law underpins the democracy. Without the rule of law, there's no democracy. I think that's the best way of actually describing it.
Advocate, there is a view from certain quarters that the State of Disaster Management Act in its current form undermines the doctrine of the separation of powers. What's your view?
Well, I'm not sure if it's been promulgated for the public good, which I think it has, especially in light of this pandemic, then I don't think it undermines it at all.
Thank you, Advocate. Thank you, CJ.
Thank you so much, sir. Commissioner Matelo Lepu?
Thank you, CJ, and thank you, Advocate.
Good afternoon.
You know, my pet subject is this issue of silk. Eh?
Yes.
When the CJ asked you about silk, you said for you it was not, important because of it tends to make sure it's actually quite the public. It's quite expensive. Do you think should we actually maintain the silk status? Is it necessary? And from what I hear, the silk cannot take mentees, or what do you call it? Master, whatever.
Pupils.
Yes. So what benefit is it to us
Well,
if we have to transform the profession?
as I understand it, the conferring of silk and the institution of silk is really an accolade to acknowledge practitioners' special skills, their that they can be trusted, etc., and things like that. There's nothing wrong with the institution of silk, I personally believe. I think it's important to give recognition to people who bring a certain amount of excellence to the law, their commitment, they bring in integrity and things like that. Yes, the problem is, I don't know why the rule is there that silks are not allowed to have juniors? I haven't really investigated. I mean, pupils. I haven't really investigated that. But certainly, the transfer of skills by having a junior system where silks bring in juniors, that's the best way of mentoring. I've been fortunate enough to have junior briefs to a number of silks at the Durban bar. And I think that's how skills get transferred. You actively look, you see, you watch how things are done. And of course, you walk away with something from each silk that you've worked with. And you sort of adapt and you implement it in your own practice. So I think the institutional silk on the whole is a good thing. I think where the problem comes in is where you have a sense of arrogance that comes about as a result of it, and that type of thing. But people are different. You get those that are caught up in their own self-importance. But certainly the silks I've worked with have been accommodating, have held me by the hand from time to time. And I don't think I would be here today if I didn't have that positive mentoring that comes from having junior briefs to silks.
So, don't you think if that it's so important that we have people who recognize you for your expertise, the sidebar should have those, because for me, the sidebar does a lot of mentoring, you know. It's very important that the sidebar has that recognition also.
No, I agree. I think we complement each other. I think ethics can't survive without attorneys. We dependent upon the attorneys, so we have to coexist. There's nothing wrong with having senior attorney status, if that's what it means. But we're not in competition. You know, this notion of us being in competition with attorneys is actually wrong. There are good attorneys out there. We've had good attorneys appointed to the bench. I think one of the people that come to mind for me is Judge Thamba Pillay, who's now retired. He was an attorney, never practiced at the bar, but was a good judge.
CJ?
Thank you. Thank you so much. Commissioner Barnard?
CJ, I'm just checking if you had me down somewhere there after Nyambi or others. Thank you.
Oh, okay. All right. I'll jot it down, sir.
Thank you.
Thank you, Chief Justice. Good afternoon.
Good afternoon, Commissioner.
Mr. Bedderson. Advocate, my question is this, you know, I'd actually want to take this point further of the attorneys and advocates and in silk. What would your advice be? I mean, because the experience is, even in this day and age, that sometimes the courts just have a lend a larger ear, if I could put it that way, to the advocates profession than to attorneys. What would you say about that?
I think judges have got a duty to act impartially. I think favoriting counsel over attorneys is absolutely a no-go area. One must recognize that the work of attorneys traditionally is totally different to that of an advocate. For example, I mean, the perfect example one can use is winding up with estates, for example. Advocates don't do that. But of course, we can advise on whether things have gone wrong, look at the law, and advise on what appropriate action must be taken.
No, but let's sorry if I can interrupt you, but let's focus on litigation, because I don't want to
Yes.
you know, stretch the point out too long, but specifically on litigation. And I want to put it to you that it's difficult sometimes for presiding officers to understand that both parties should be equally listening. Let me give you an example. What would your advice be to a magistrate, for example, who has appearing before her or him a candidate attorney on the one hand arguing a point, and in opposition there's an SC standing arguing? Wouldn't you agree it's difficult for that magistrate to not lean over and listen more to the SC?
Well, I think if that happens, she shouldn't be there. It's all about preparation, Commissioner. If the candidate attorney prepares his case properly, he might surprise that silk. So I think having a skewed and lopsided approach in dealing with practitioners that appear in front of your court, I think that's unacceptable.
Thank you. And then what would you regard as your high point and your low point of your 24 weeks on the bench?
Initially, you're quite intimidated because remember, I spent a large part of my life being on the other side. You certainly do see things from a different perspective. So that was the low part of it, I think, intimidated. And I think my experience carried me through, especially when I sat through my first motion court. I came out of it and I couldn't remember what happened. But yeah, if you don't have the experience, you're definitely going to battle. So you have to cut your teeth by actually practicing in that court. If you haven't, it makes life a lot harder.
Thank you. Thank you, Chief Justice.
Thank you so much, sir. Professor Shlema.
Thank you, CJ. Good afternoon, sir.
Good afternoon.
Would you like to share your judicial philosophy with us, please?
Well, I think it's imperative that you treat people with courtesy and respect, everybody that appears there, whether they are practitioners, the general public, court staff, and of course, you must deliver your judgments promptly, treat people fairly, keep an open mind, and of course, apply the Constitution. That's of paramount importance.
Thank you. And your understanding of the rule of law that links up with what Commissioner Nyambi asked you earlier.
Well, if we don't comply with judicial decisions, undermine the rule of law, then it's chaos.
But what is the rule of law?
It's complying with your constitutional obligations, etc.
Thank you, sir. Thank you, Chief Justice.
Thank you, Prof. Commissioner.
Thank you, CJ. Good morning, Advocate.
Morning, Commissioner. Good afternoon, I think.
Is it good afternoon? Yes, it is good day. Yes. Can I ask you just to follow up on Prof's question on your judicial philosophy? Are there any judgments that you have penned while acting within your 24 weeks that shows your commitment to constitutional values? And can you share those with us? Thank you.
I think when one is writing any judgment, at the back of your mind, you have to comply with the Constitution. The judgments you have seen that I've penned deal with administrative law. I think the one was a matter involving the Pietermaritzburg municipality. The others dealt with insolvency related matters. So your judgments have to comply with what is espoused in the Constitution. But having any, I haven't had any constitution related matters that I had to adjudicate on.
Thank you. It was about the other judgments that,
yes,
like you have said. Thank you. Just the last, my question actually to you was, over and above the 24 weeks that you had acting in the KZN High Court, what other adjudicative roles have you played that would assist you in your role as a judge were you to be appointed? And how has that helped you?
I've sat as an arbitrator in a number of arbitrations and disciplinary committees outside of the legal profession in my capacity as a member of the school governing bodies and things like that. And of course, as I've mentioned earlier on, I've sat as the chairperson of the Tax Appeal Board on a number of occasions.
Thank you, Counsel. Thank you, CJ.
Thank you.
CJ, can you
Thank you so much, Commissioner. Or was there a colleague speaking?
CJ, can you note Makwanisha?
Thank you, Honorable Makwanisha.
Yeah, yes, CJ. Thank you very much, CJ. Good afternoon, Advocate.
Good afternoon, Commissioner.
Thank you so much. You have acted in various RAF and medical negligence matters.
Yes.
From 2008, I mean, the country experienced a spike in medical legal claims that today the state is sitting at about over R1 billion of medical legal claims. What do you think is a problem that we saw this spike from 2008? What has gone so wrong that we are experiencing this as a country? And maybe you may want to sponsor a view on that. Thanks.
I think what happened with the work in the RAF lineup, some practitioners moved over to the medical negligence aspects of practice. There's certainly been highlighted an explosion of negligence in the public hospitals. I'm not sure what has been done to remedy that. I think that's one of the multifaceted problems that we face. And then we've got practitioners lodging these claims for indigent clients. I think the MEC's office must deal with them constructively. For example, if there's a defense, they must defend it. Certainly if they're found to be liable, then they must be proactive, put in tenders that put people at risk. At the moment, what's happening is that the litigation has taken right to the doors of court and then settled. Millions of rands have been spent on litigation costs. I was privy to attending a meeting with the ex-acting state attorney in KwaZulu-Natal when this matter first reared its ugly head. And she wanted to discuss how one can best deal with it. And I said to her that they have to use the rules of court effectively, put in tenders, assess what the claim is worth if liability has been resolved, and put in tenders. Half these matters will fall away by the wayside. That hasn't happened. I've acted for the state, for the MEC's office, prepared opinions on what the claim is worth, filed the opinion with the attorney, given to the relevant officials. It takes 1 year for them to come back and agree to put in a tender. So there's problems, and I think the litigations have been handled in a constructive manner. Like I said, the duty to litigate responsibly is not only on the MEC's office, but those people representing the MEC themselves got a duty to litigate responsibly.
Thank you very much. We are talking about claims against medical legal claims against the state. Yes. What is your view with regard to medical legal claims against the private sector? Is it also seeing a spike, or it's more on the side of government?
I think it's more on the side of government. I think medical claims in the private sector are hard fought. The insurance companies that insure the medical practitioners fight those cases tooth and nail.
Thank you, CJ. I'm covered. Thank you, Advocate.
Thank you, sir. Honorable Singh.
Thank you very much, Chief Justice, and good afternoon, Advocate Bedderson.
Good afternoon, Commissioner.
Yeah, two questions. Just one, I note that in our documents, a BLA has objected to your appointment on the grounds that they say you should act more. What do you have to say to that before I go to my second question?
Yes, that was an old report. If you recall, I shortlisted for the session that ought to have taken place last year. I think at that time I had 3 acting stints under my belt. At the time that they had prepared their report, I had 2 acting stints. The 3rd stint was a criminal stint that took place in March of that year. So one can really not criticize them. At the time, they only had information that I'd only acted on had 2 stints under my belt. I think things have changed dramatically since then.
No, thank you for that. I think the JP has confirmed that. The second thing, I was reading just a summary of one of your judgments, and what reminded me was Commissioner Madonsela, who spoke about children, and I didn't ask the question about children. As Boniso Tlabisa versus the state.
Yes.
I think the matter was heard on the 7th of June, 2019, and you delivered judgment on the 28th of June. And it's a matter that came for you to deal with the sentencing part. I think, and the accused was found guilty, pleaded guilty, and was given life sentence by the magistrate, and then you reduced that to 18 years. But when I read there, it says, Bedderson AJ held, and I want to quote, "It is clear from the reading of the judgment that the magistrate," and I'm continuing to quote, "overemphasized the seriousness of rape of young children." Just want to repeat that. The magistrate overemphasized the seriousness of rape of young children. Now, that sounds to me a bit concerning when I read it. And I'd just like to know, what were the circumstances there? Because I think our attitude towards rape and sexual violence and gender violence, especially against young children. And this child was 6 years old. Thank you.
Yes, I agree. I think when you read it in that context, it probably induces a sense of shock in a way. But what we had to look at is look at the sentencing option holistically, see whether there is any prospect of rehabilitation, all the normal factors that you'll take into account in sentencing, the circumstances under which the crime took place. And we found, both the judge president and I, that this holistic view wasn't exercised by the magistrate. She hadn't taken into account what is set out in State versus Zim, for example. And you'd see that the reduction in the sentence to 18 years is not insignificant. So while it reads like that, that wasn't the intention. It wasn't the sole factor that we took into account. I think it's reprehensible that anyone can rape a child of 6 years old. I've got a daughter that's 6 years old, by the way.
Yeah, and that is why, Advocate, I asked that question, when I saw your children, because I didn't think that, you would mean what you said there when you said that he overemphasized the seriousness of the rape, because, I mean, that kind of thing is like you say, it's just not acceptable in our society. All right, I wanted to ask you that question and I've asked you. Thank you.
Thank you, Commissioner.
Honorable Magwanisha.
Thank you very much, Chief Justice. Good afternoon, Advocate.
Good afternoon, Commissioner.
In your response to the question asked by the JP, you said you like your sleep.
Yes.
And I must say I was very relieved to hear that. Because in the studies conducted by the Bar Council of England and Wales, it was found that many barristers are suffering from depression and stress, high levels of depression and stress. Hence, they are focusing on wellness programs. How do you balance work and your other hobbies to keep a healthy lifestyle?
Well, at present, I work during the week, flat out. I try and leave work at work if I can. It doesn't happen all the time. If you've got trials that are starting on the Monday, for example, you'll find in Sunday afternoon, you'll break away from your family and go sit in your study or drive to Chambers and spend another 2 or 3 hours preparing. But I think to be effective, you have to have a balanced life. And the work is stressful. The workload is stressful on the bench. And I think the sooner you get stuck into your judgments, the better. I think if you leave them too long, you're going to fall into trouble. You can't remember exactly what happened last week, let alone last month or the last 4 months. So advice I received from senior members in my group is just get it done. It doesn't matter what the first draft looks like. The first draft is always an horrendous draft, I think. But get something out on paper, and then you can play around with it, improve it. But at least there's a first draft. I think the other problem is also reserving too much judgments. I'm not saying that you must give extemp judgments as a matter of course, But certainly matters that can be disposed of by using your wealth of experience and areas of law that you're quite au fait with, then give extemp judgments. You might finish argument at 11:30, stand the matter down until 2:00, give judgment at 2:00. So I think if you reserve too much, and I'm not saying judgments mustn't be reserved. I think there are matters where you have to really give it considerable thought, reasoned thought, but the trick is to get it out. Also, life becomes a misery, I think.
Thank you, Chief Justice. Thank you, Advocate.
Thank you very much, sir. Your excuse, Advocate.
Thank you, Chief Justice. Thank you, Commissioners.
Thank you.